The top story tonight, President Uhuru Kenyatta, former Prime Minister Raila Odinga and other proponents of the Building Bridges initiative today began the tough battle to rescue the BBI referendum push before a 7-member appellate court bench. And as our senior political affairs reporter Murimi Mwangi now tells us, Attorney General Kihara Kariuki's legal team set the ball rolling with arguments in defense of the legality of the BBI, the president's hand in the process and the sanctity of the process leading to approval of the BBI bill by a majority of county assemblies and parliament.
On which grounds of appeal?
A battery of robbed lawyers, led by senior counsels, and volumes of documents in support of and against the Building Bridges initiative colored the commencement of the legal battle to rescue the President Uhuru Kenyatta and former Prime Minister Raila Odinga-led BBI constitutional reforms.
The people must retain their sacrosanct right to live by the Constitution that they chose for themselves and to develop it as they may wish.
Attorney General Kihara Kariuki, through Senior Counsel George Oraro and lawyer Kamau Karori, the first to defend the BBI, before the Justice Daniel Musinga-chaired 7-judge appellate court bench, the AG disputing the High Court ruling that barred what they termed as a structural alteration of the 2010 Constitution through the BBI, as he also attempted to prove that there was adequate public participation through the entire BBI process.
This bill was going to go to the referendum. It's my humble submission that all these issues, any issue that would be raised regarding the popularity or the suitability of this bill is an issue that would have been raised to the Kenyan people in the referendum for them to decide for themselves.
The High Court had also, in its ruling, affirmed that Kenyatta, as a sitting president, was constitutionally barred from championing constitutional amendment by popular initiative, a finding the AG refuted, as he also queried the High Court position that a sitting president could be sued in court.
If violates any provision of the Constitution, the path is impeachment by Parliament, not the courts. Just like my lords, judges cannot be tried for violation by the court. They have to go to a tribunal set up under the Constitution.
Under Article 257(2),
Yes.
A popular initiative for amendment may be in the form of a general suggestion or by way of formulated as a bill. Do you see a situation where those who wield state power can make a general suggestion? To whom are they making that general suggestion?
And the president can make a general suggestion or can make a suggestion
to his government,
to the people, to consider an amendment to the Constitution. They can make a general suggestion to be considered. And if then it is supported by 1 million voters, it becomes a popular initiative.
Yes. The BBI Secretariat also defended the document through the Siaya Senator James Orengo-led legal team.
The record will bear out that at every stage in constitution making in Kenya, it's only when we came together, including politicians and presidents, that this process went ahead.
And if you read the report of the Committee of Experts, they were looking at many different documents so as to come up with a draft constitution. And there were very many other processes that involved politicians. And as I will be submitting later, some of the things that were being viewed by the court as part of the basic structure, for instance, the presidential system of government, was actually given to us by politicians sitting in Naivasha.
The case continues Wednesday, with electoral body IEBC next on the stand. And as the BBI resuscitation battle officially commences, the puzzle of the balance between political and legal questions heavily weighs on the 7-judge bench as the hearing continues. Murimi Mwangi, KTN News, in Nairobi.
Meanwhile, it was a round 1 win for the Independent Electoral and Boundaries Commission, IEBC, and the proponents of the BBI constitutional reform.